Mr. Nettleton, I believe you represent the appellate in this matter. Is that correct?
Yes, Your Honor.
And did you wish to reserve any time for rebuttal?
Yes, I'd like to reserve 4 minutes, please, Your Honor.
Thank you. I have made that notation. You may proceed.
Thank you. May it please the court, my name is Paul Nettleton with Carlton Fields. I'm here on behalf of the appellant, Alberta Ellison. Your Honors, we're here asking that this court reverse the $30 million judgment that was entered on the jury verdict below in this personal injury case. We've raised a number of bases for that reversal, and I'll tick them off very quickly and then address them individually or at the court's desire. First, we submit that a new trial is required because of the injection of the idea of liability insurance being available to pay any award in this case. Second, we submit that the future economic damages that were awarded by the jury were not supported by any competent evidence and were based on speculation that the plaintiff's wife was going to leave him either immediately or in the future. Third, we submit that the $18 million awarded for future non-economic damages is against the manifest weight when all the evidence is considered here. Fourth, we submit that the trial court erred in not allowing a $4 million set-off to the judgment based on a settlement that the plaintiff entered into with his carrier for a bad faith claim in which he sought the exact same damages that are involved here, the damages arising from the accident. And then last, Your Honor, we submit that the vicarious liability cap of 324.021 should be applied in this circumstances, but acknowledging right up front that this court has held otherwise in Ortiz because this is a co-owner situation. With those points in mind, Your Honor, I'd like to address the insurance issue.
Before you start, don't worry too much about making your argument about Ortiz. The fact that I wrote it does not mean that I think I'm omniscient, all-knowing, and always right. So give it your best shot.
I understand, Your Honor.
Don't feel intimidated.
And I understand Judge LaRose was on the panel as well. And my only comment on that was going to be we request that the court certify the same question of great public importance that it decided to do in Ortiz. But
they didn't take it up, apparently?
No one took it up, Your Honor. So, Your Honor, turning to the insurance question, this was first injected into the case in voir dire by plaintiff's counsel in response to one of the veneer person commenting about
Mr. Nettleton, let me share my concern with that. I'm not sure as a practical matter what I'm supposed to do as a trial judge or as a lawyer when these comments are uninvited, unsolicited, and I'm having a hard time agreeing that the comments were pervasive throughout the voir dire. But help me with my practical concern about what a trial judge or a lawyer is supposed to do when a juror just decides to start talking about this stuff.
Yes, Your Honor. Well, first of all, it wasn't just one time. This happened 4 or 5 times during the course of voir dire, all within a fairly short space of time that was triggered by this. But what the trial court should have done is what defense counsel asked the trial judge to do, and that was strike the veneer. Now, it was motion for mistrial is what he termed it, but everybody understood he meant to strike the veneer. We were in the first day, jury selection. It wouldn't have been that disruptive. You bring in a new set of panel and you deal with it. But in this case,
Mr. Nettleton, and just sort of cut to the chase here. In looking at the case law on this, I hadn't been able to find an opinion that condones the relief that you're asking for. I've seen it done. I know what you're talking about, but in terms of just starting over with a new panel. But I struggled with finding any sort of case law that paralleled these circumstances where basically a juror gratuitously offered a statement. It happened a few times, and either an appellate court decided that a new veneer would have been appropriate or a mistrial was appropriate on the back end. And the 3 cases that you relied on in your brief are readily distinguishable because attorneys were injecting the issue of insurance in various parts of the trial. So have I missed something? Is there some case law that specifically lines up with what you want us to do here?
If Your Honor, if you're asking if I have a case that says where a veneer person brought something up, no, I do not. But let me tell you why that doesn't matter. I would suggest here, and I won't go through each of the statements. I think they're very important, though, because they go right to the heart of why this type of stuff is not allowed in front of a jury. And that is because it suggests, as the Supreme Court said back 70 years ago, that they'll be more, they'll award excessive amounts because they don't think the defendant's going to have to pay for it. And Your Honor, the reason it's bad here because a veneer person said it, it doesn't matter whether it's invited, whether it's inadvertent. It's the same sinister effect on the jury. I would submit to you that if these comments that were made, that the insurance company is going to pick it up, the insurance company pays for your damages, those kind of comments had been made by plaintiff's counsel in this case, or a witness from the stand, there's no doubt that this would require a new trial. The veneer person saying it here, I submit, makes no difference. It has the exact same sinister effect on the jury that ended up hearing this case. And in fact, I would suggest it would be even worse, because here we have one of those veneer persons who was saying the most egregious things was an insurance adjuster, and the veneer knew that. The jurors ended up serving knew that. She had no interest in the outcome of this case, and so her comments could be viewed as having extra credentials of almost an expert because she's in the industry and telling everyone the insurance company is going to pick up the bill.
Would it have been appropriate to move to strike her? Because I'm trying to figure out how you can show that the rest of the veneer was tainted by her unsolicited comments.
Well, the same way if a counsel had said it or a witness says it from the stand, that's the taint. It's the fact that it's being said and voiced to the jurors, Your Honor. Yeah, she was stricken for cause in the end, and none of these people that actually made the comments were on the jury at the end. The point was that the jurors heard all this stuff during voir dire, during a short period of time, over and over again, that the insurance company was going to pay for something like this. Now, I would refer, Your Honor, to the Pensacola Transit versus Denton case, which we cited. It addressed a situation where the defendant was on the stand, and the only question asked was, at the scene, did you tell the plaintiff that you had insurance or you were insured?
Well, Mr. Nettleton, the suggestion was made by counsel that the defendant was insured, and here I don't think there's any fair read of the comments that were made by the jury panel that insurance was really in play here. So I'm not sold on Pensacola, but I take your point. And what I'd like to ask you, because I'm afraid we're going to run your clock out before you have a chance to address some of your other points, I'd like you to address the argument, your fourth point, the set-off argument.
Yes, Your Honor.
And hopefully you'll get some time to come back to everything else you want to talk about.
Yes, Your Honor. On the set-off, Your Honor, there's the record shows that the plaintiff here sued his carrier for $10,000 in benefits, along with bad faith for not paying it. In the bad faith claim, specifically requested recovery of damages caused by the accident, which is appropriate in a bad faith case under the statutes. He settled that claim for $4 million. That's undisputed. We're in the somewhat unique position here. This court actually has examined this settlement in a previous case. In Willoughby versus Aka, and Judge LaRose wrote the opinion in that case. The court found that $4 million settlement compensated Mr. Willoughby for damages he sustained in the automobile accident and provided compensation for all injuries Mr. Willoughby suffered. It follows as a result of that. He was sued. The same damages that they were sought against Ms. Ellison in this case are the damages that settlement was related to.
But does anything in excess of the $10,000 fall within the rule that benefits would not be an offset?
No, Your Honor, certainly not. I would submit even the $10,000 doesn't fall within it. And that's where the trial court, I submit, was led astray by counsel using these cases that date back to the Nierhoff decision in 1972, which were applying the common law collateral source rule. The common law collateral source rule was abrogated by the statutes, and notwithstanding there's still cases following Nierhoff, they're just not recognizing that abrogation. So I'd question the continued viability of those cases. But aside from that, there's certainly nothing above the $10,000 that would be benefits that would fall within those line of cases. And in fact, I believe counsel even stated that it was undisputed in that regard, and that's at page 3167 of their response to one of our motions, Your Honor. So clearly we're entitled to it. Which statute? We cited 768.76. Council says that doesn't apply. We don't agree. We think that the language of defining collateral source there to include contracts or agreements to pay for medical expenses and wages from loss from disability could encompass this settlement agreement we're dealing with here. But
the UM benefits, that was something that Mr. Willoughby was paying for, correct?
Correct, Your Honor. That was the $10,000 in limits, correct. So, and you get an offset for those premiums if you wanted to.
To be entirely clear, Mr. Willoughby bought uninsured motorist coverage for whatever premium he paid for it for just such occasions, and he presumably expected 21st Century to answer a claim for that, and that's how they didn't, and that's how he wound up, or at least he thought they didn't, and they felt sufficiently insecure about that they were willing to pay over the bad faith settlement, right?
Correct, Your Honor.
Okay.
Yeah, they denied coverage on it.
And I think where I understand what you're saying about Muirhoff and the evolution of this law, but the fundamental recognition that, as between a windfall to the insured in this setting and the other result, given the insured's purchase of the UM coverage, that I'm not sure that principle has fallen by the wayside to the extent some of the other aspects of UM jurisprudence may have since the early 70s. Please address that.
Yeah, well, I'm certainly willing to give up the $10,000, Your Honor. If we get the 3.99,
you might need to because it's not preserved. But go ahead.
Well, I think it is very much preserved, Your Honor, because we not only did we cite 76.76, we also cited case law applying 768.041.
I was referring to the 10. I think the preservation argument on the two statutes is different.
Go
ahead. I don't want to distract you.
Under 768.041, which counsel seems to suggest is the more appropriate, and we don't necessarily disagree with that. I think it's recoverable under either, the set-off. But we did argue the very principle of that statute. I mean, that was the whole basis, that this was a double recovery. Addison says under Florida law, a plaintiff is not entitled to double recovery of the same damages. And that's what we're dealing with here. That's what was argued. That was the principle argued. And in fact, counsel was aware of that because in their response to our motions, they argued against both statutes, both 768.76 and 768.041. Their argument on 041 was that you had to have joint tortfeasors, and that's just a misunderstanding of the law, Your Honor. Joint tortfeasor is not required. That's slipped into the case law because really what's crucial is it's the same damages being sued for. Usually that is in a joint tortfeasor situation, which is not the situation here. But as we cited to the Jacksonville versus Outlaw case, the Grubman case versus Posey, those were clearly non-joint tortfeasors where the court found that 768.041 required set-off of the entire settlement. And another on the other 10,000, Your Honor, this was an unallocated settlement. And then there's case law from the Supreme Court on down, including Addison, that discusses a lot of it. Where it's unallocated, you get the entire amount of the total settlement for set-off. So we would submit that the court clearly erred in that regard. Turning to the damages issues, Your Honor, we believe that the economic damages were not supported by competent evidence. Their expert in this regard prepared two life care plans. The first was called Updated Life Care Plan. And he testified that specifically was based on Mr. Willoughby's current scenario, current living conditions. Then he prepared another one 3 days later, Life Care Plan in the Absence of Miss Lewis. And that was over $4.7 million more than the earlier one 3 days earlier. And what he said about that one was he said, first of all, it's not based on existing facts or even probable facts, but rather assumed, and I'm quoting, something were to happen to her, that would be a second scenario in the absence of her. That's 4114, where he's explaining these two plans. And there's no mystery where the plaintiff was trying to go with this because they asked their neuropsych on the stand about divorce rates for people with traumatic brain injury. That got cut off by the trial court in trying to transition that over. But nevertheless, it wasn't lost on the jury, and that's what this was about.
I thought the expert made an effort to explain that these are services that Mr. Willoughby needs, period. And there's a value to that. And wasn't there enough before the jury as to Mrs. Willoughby's activities for them to have said, well, we can shave this down a bit because she's now providing these services?
They certainly could have done that, Your Honor, and they did it slightly, I think, by $20,000. Not the multi-millions that were in play, because
but that was an argument that was an argument that your client was advancing, that, you know, let's assume that he's going to need X number of dollars. Your position was, well, not really, because Mrs. Willoughby is providing many of these services now.
Well, what we were arguing, Your Honor, is that Dr. Shanasarian's initial plan, he testified that he did not need these things. He specifically defined in the thing that they were not probable for the attendant care, for the nanny, and then other ones which he did have in that first plan. He said that they were at a lesser frequency. Those were his opinions that he expressed, and this other plan was only if she's not around, and that's the speculative nature to it. Otherwise, we're talking hundreds of thousands instead of over $5 million. And we submit that because the jury relied on this life care plan and the testimony about it that was based on her not being around anymore, and there was no evidence to support that. All the evidence was they had a very strong marriage. They got married after the accident. They had a kid after the accident. They were expecting another child at the time of trial. It was also, we submit speculation and doesn't support the award. So we'd ask that be reversed. And then
you are at 16.
Okay, thank you, Your Honor. I'll reserve the rest for, well, let me just take 30 seconds off my time. And that is just on the final, the $18 million for non-economic damages. We think it should shock the judicial conscience. If you look at all the record here, counsel suggests that there was no improvement after the third year. We submit the evidence is not so. There were doctors, no doubt, including our doctor, who used the word plateaued after the third year. Nevertheless, there's testimony that he was continuing. It was substantial improvement, obviously, from the accident through the third year. Even Dr. Shanasarian said when he interviewed him more than 6 years after the accident, he had noticed tremendous improvement. And Dr. Hayes, who was his main treating physician for the brain injuries, also recognized his cognitive condition was greatly improving and would continue into the future. So again, whether it shocks the judicial conscience or not, I'm not going to convince you one way or the other. It's up to you to look at the evidence and make that decision. But we'd ask that we get reversed for each of these issues, Your Honor.
Thank you, counsel. Okay. All right. Mr. Cathay, you may respond, sir.
Good morning. May it please the court. I'm Brandon Cathay. I represent Randy Willoughby, the appellee. And Ms. Ellison's 5 complaints of error here just simply aren't supported by the record. As to the first issue about the insurance comments and voir dire, their complaint is that in their brief was that the trial court abused its discretion when it failed to grant a mistrial after, quote, half a dozen statements were made, direct statements that insurance would pay for plaintiff's damages. And here in oral argument, it's been said that the issue of liability insurance was discussed, but the facts of the record speak for themselves. No one ever said that the defendant had insurance or liability insurance. That was never said. Nobody ever said the defendant's insurance was going to pay for this. Those comments just were never made. The defendant asked for a mistrial about 2 unprovoked statements of this insurance adjuster. There was no other statements were preserved. There was no objection to anybody else's commentary. And so the only thing that they could complain of, though they didn't make this their complaint of error in their brief, was about the insurance adjuster, Ms. Mineson's comments. And she didn't, her quote was more of a question than some kind of a statement about whether the defendant would be paying it. She said, quote, "Most of the time in this kind of situation, insurance is going to pick it up. If I'm not mistaken, maybe I'm wrong." And this was in the context of her acknowledging that, wealth of the parties and how much resources people have isn't relevant to anything. She understood that, and that was it. So it's really a single comment. She also kind of spouted off a little bit when one of the other veneer members mentioned something about having a teenage driver, and she said, buy an umbrella policy. And that's it. Those are the two comments that we're dealing with here. As Judge LaRose pointed out, the existence of insurance is commonly brought up. I mean, there's probably not an auto wreck voir dire that happens in Florida where insurance doesn't get mentioned. I mean, if you ask the veneer if they've ever had an auto accident, they're going to bring up insurance. If you ask if they've ever been in a civil lawsuit, somebody's going to have been in an auto wreck that led to a lawsuit where insurance was involved. They talk about plaintiffs' lawyers on contingency fees, other people's lawsuits and claims, and insurance. It comes up all the time. And like every other irrelevant kind of thought that jurors have, we have to trust that when they go on the jury, they're going to disregard those and follow the instructions of the court. And there's just nothing to suggest anything like that occurred. The judge gave a contemporaneous comment of his observations in the transcript at 3497. He said, I don't think it was harmful. That's my call based on the totality of the circumstances, listening to the voir dire. I just don't think we've got a tainted panel. And so to say that the court, no reasonable judge could refuse a mistrial following those comments is just a burden that Ellison is unable to meet here.
Mr. Cathy, let's talk about the set-off.
Yes, the set-off.
You can't really dispute that your opponent at trial argued case law that incorporated references to both of the statutes. So for purposes of our discussion, I'd like you to assume that their argument is preserved as to both 76876 and 768041. And my question to you is, the text of that statute of 0412 provides a set-off for a settlement if the defendant shows that the plaintiff has delivered a release or covenant not to sue to any person, firm, or corporation in partial satisfaction of damages sued for. And our record shows that Willoughby in 21st Century settled for all claims related to the accident. And those claims included his physical damages. So tell me how we don't have to apply this statute to this record?
Well, Your Honor, a couple of reasons. The first one I would say is, and we cited some case law on this to Addison Construction Corp versus Vicellio, where courts talk about how if the settlement funds are applicable to a claim asserted only against the settling co-defendants, the non-settling defendants are not eligible for a set-off in the amount of the settlement. That's the quote. And so here, Ms. Ellison was never sued for bad faith. They just simply were not sued on the same claim, which is, I'm sure, why below their only argument was as to 768.76. Their motion was to determine that this was a collateral source under that statute. I think Your Honor also pointed out that there's a fundamental kind of rule that runs under all of the decisions that deal with this. In court, including, importantly, this court's decision in Obenlund, which is that the principle here is that because the plaintiff recovers from their uninsured motorist carrier who they paid premiums to, the tortfeasor should not be relieved of its liability because of something that the plaintiff recovered from the uninsured motorist carrier. Obenlund's a really important case because while it's true that almost all the cases are always talking about the benefits themselves not being set off, that they recovered the actual policy benefits and that those wouldn't be set off. This court in Obenlund took this a step further, addressing a statutory payment. In Obenlund, the court was confronted with the idea of what happens under 627, 727 sub 6B. We're under the same statute here with bad faith where it's sub 10. But under sub 6B, where the carrier can pay directly the liability of the tortfeasor in order to preserve its subrogation rights. The argument was made in that case that there should be a set-off for that payment. So now we're not talking about just benefits, but a statutory payment under 627, 727. And this court said, for the same reasons as all the cases that preceded it, that the policy of the state of Florida is that it is better that the plaintiff get extra money than for the tortfeasor to be relieved of its responsibility.
Well, part of that policy does turn on the availability of subrogation. You would agree, right? And the only amount of this $4 million that was going to be subject to subrogation was the $10,000 in benefits. Certainly the bad faith portion, which was by far and away the lion's share, wasn't something that could be subrogated, right?
Well, it's not dependent upon subrogation. There is, if a
but that's a
collateral
factor in these decisions that you're relying on, was the availability of subrogation, isn't it?
Well, when a payor meets the definition of a collateral source, then the issue comes up, well, do they have a subrogation right? Because if they have a subrogation right, we back them out again and say, no, they're actually not a collateral source after all. In this case, they don't meet the definition of collateral source in the first place. And the question is actually entirely unanswered in the case law about whether 21st Century has a subrogation right in this situation. It's just not answered. And so I don't know that we can say that it's the law that they don't have a subrogation right. But more importantly, that's not the issue that determines whether or not they get the set off. That's if they are a collateral source, but there's a subrogation right, then there's still no set off. In this case, their argument below, the only argument that they made was that they were defined as a collateral source under 76. Here at oral argument, they've said they still believe that to be the case. And so it turns on whether or not the court was wrong in determining that the settlement paid by the insurer, which was in excess of the policy limit, didn't meet the definition as health benefits or disability benefits. And seeming to anybody, I mean, this isn't, I won't say any more, but I don't know how we say that this qualifies as those things, that a bad faith settlement is somehow health insurance. It just doesn't add up. Now, the Supreme Court in 72 in Neerhoff, it was mentioned, says explicitly, neither 768.041 nor 627.0851, which is now 627.727, authorize such a set-off of insurance benefits received as a result of carrying coverage in favor of a joint tortfeasor. General principles of
bad faith payment is not insurance benefits, is it?
No, I would not say that it's insurance benefits, but they go on to say that general principles of law relating to the collateral source rule precludes allowance of such a set-off. In other words, we've got this overarching thing that the tortfeasor is not going to pay less than they owe because of a settlement that the plaintiff received from a insurer. And this court in Oberlin took that to the next step and said that includes more than just when they're paying the coverage. That also includes statutory payments under 627.727 sub 6. And so we're saying Oberlin's the only extra step that need be taken is to say that also includes payments under 627.727 sub 10. That's the statute that the appellant is relying upon, which says that the bad faith damages are the damages caused by the tortfeasor. And so just like in Oberlin here, this is a statutory payment for which the tortfeasor doesn't have its liability reduced. I guess I don't have anything more to add to that. On the insurance and voir dire, I guess we've kind of gone over that. The statements were probably permissibly made, but even if they weren't, the question really is, did the trial court abuse its discretion in not granting a new trial? The only authority cited in the brief of the appellant is Harrison versus Gregory. And Harrison really supports our position. In Harrison, while they did reverse the trial court, and one of the grounds was because of a statement that an accident reconstructionist made, so evidence to the jury saying that the defendant's vehicle was brought to the tow yard by its insurance company. And the court, although they reversed, said that if that had been the only comment, we'd affirm. And so we think Harrison really supports us on that these types of statements, even if they're concrete statements by witnesses, if it's just an isolated thing, isn't grounds for abuse of discretion reversal. To address the future medicals, Similarly, Dr. Shanasarian never testified that Ms. Lewis, Mr. Willoughby's wife, was going to leave him, and that his opinions were based upon that assumption. That simply wasn't said. He said, just as Judge LaRose pointed out, this was what his needs were, period. This was the defense's argument that the damages should be reduced as a result of the fact that his wife could provide some of these services. Importantly, no challenge was ever made to Dr. Shanasarian's testimony. There was no Daubert challenge. There was no voir dire of his testimony. There wasn't even an objection to it. And so once that evidence was admitted, of course, the trial court, now looking at the question that's on appeal, was there competent substantial evidence to support this award? Yes, there was the unobjected to testimony of Dr. Shanasarian. And so now on appeal, they want to say, well, that was speculation. I mean, it wasn't speculation, but even if it was, it's just simply not a preserved error. On the non-economic damages, similarly, in the initial brief, the appellant said that the trial court did not act reasonably and ignored the evidence in denying Ellison's motion for new trial because the evidence does not support plaintiff's request for and the jury's award of nearly $1 million per year for the rest of plaintiff's 51-year life expectancy for future pain and suffering. Well, the plaintiff didn't request $51 million, and the plaintiff wasn't awarded $51 million. The plaintiff was awarded 35% of that number, $18 million. So on that basis alone, the complaint was $51 million was excessive. They've got a actually 65% discount if they look at the verdict. And so the standard there, of course, isn't whether the trial court acted reasonably anyways. It's got to shock the judicial conscience. The undisputed evidence, this was from the board certified neuropsychologist expert of the defense on the stand, said that Mr. Willoughby suffered, quote, a very, very severe permanent brain injury, end quote. And as a result, he continues to, quote, suffer from very significant cognitive, emotional, and behavioral problems, end quote. And so the fact that his damages were enormous was really not in dispute. You know, pages 5 through 10 of our brief, as well as 34 through 36, we catalog all those things. But I mean, if Mr. Willoughby, given all of the injuries that he's going to suffer with for the next 51 years, can't justify $18 million, there's probably not going to be a plaintiff who's ever going to be able to present evidence of $18 million in future non-economics. The cap, I guess we didn't really address, that wasn't really addressed by the appellant, but we don't think that there's a reason here to recertify a question of great public importance. There's been not only time, but additional precedent since the time of Ortiz. There's been absolutely no contrary court decision or legislative action since Ortiz. This court in Youngblood versus Villanueva in 2014 cited its precedent and discussed it again in Ortiz. It's still the case that loan is unambiguous. The fourth DCA has also gotten in on this question, cited favorably to Ortiz and discussed it and cited to it as it is unambiguous, cited to the court's definition for what a loan is, and this court's source to Black's Law Dictionary, as well as looking at a different statute for a definition. And then the fourth even added its own definition from Random House Dictionary. Everybody agrees a loan is a grant of temporary use of something. The Supreme Court in Gowdy versus Schneppel said that because the legislature has failed to make any substantive changes to the pertinent statutory language, we must assume that it has no quarrel with this court's interpretation of the statute. We have similarly here no legislative response suggesting that the legislature disagrees. In their brief, the main argument seems to be that the court should examine the legislative history. Of course, we don't look at legislative history unless we find there's an ambiguity. But even when we look to the legislative history, we see that the appellant kind of misstates what's actually in the staff analysis of the legislative history. They cite subsection 9B3 is added to apply the same vicarious liability limitations to owners who are natural persons, period, suggesting that the idea of loan wasn't really part of the intent of the legislature, but they truncated the sentence. The full sentence is subsection 9B3 is added to apply the same vicarious liability limitations to owner who are natural persons who lend their motor vehicles to permissive users. And so there's simply no reason to certify it as a question of public importance of the Supreme Court for that reason. But in addition, the Supreme Court has ruled in Christensen versus Bowen in 2014, although they didn't cite to Ortiz. This was a situation with co-owners. And, you know, the court's ruling in Ortiz is kind of a two-parter. The first part is the definition alone, but then the second part is the acknowledgement that a person who has an absolute perpetual right to use an object can't have that object loaned to them by someone else. And that part of it has been adopted by the Supreme Court. And that's kind of the most critical piece. And in Christensen versus Bowen, the Supreme Court said a joint title holder holds a joint tenancy interest in the vehicle and accordingly has the right to possess and use the vehicle. So there's, you know, in that case, it was an ex-husband who was still happened to be on the title. And they said, he's still on there. They weren't looking at the cap, they were looking at dangerous instrumentality. But nonetheless, there's just really there's no contrary authority going the other way on this at all. It's all going one direction. And so there's just not a reason to send this question up to the Supreme Court. That was a point I should have made as well about the set off. That's an important thing too. All of the case law on this goes the same direction too. It's either it's coverage, whether it's statutory payments, whatever shape and size it comes in, the court every time says it's better that the tortfeasor pay what they owe than for them to be relieved of that simply because the plaintiff's carrier paid them money. There's no authority going the other way. There's not a car going in the other lane. And so the court's really got to step outside the law to create a rule to grant that cap. With that said, I mean, I'm certainly happy to address any of these things in more detail. Obviously, we've got notes and cases and disagreements about 1,000 things. And but if there's nothing else from the court, I'll wrap it up and just say this: the trial court said at the motion for new trial hearing after the case concluded, that it certainly was one of the crisper and cleaner trials that I've done. There was little drama. And the defense counsel said, yes, I tend to agree. The court also said at the end of the trial, the last lines of the trial transcript itself were, counsels, everybody did an outstanding job. I taught at Stetson for a number of years, and there are some parts of this trial I would love to have videotaped to show my students, to show them how you should do it. That's it. Thank you. So for those reasons, Your Honors, we request that you affirm the decisions of the lower court. Thank you.
Thank you, counsel. You have 3 minutes remaining for rebuttal, counsel.
Thank you, Your Honor. On the insurance issue, first of all, what counsel said to the veneer on the first instance was there a concern that a big verdict would increase insurance premiums, and I'm quoting, not just the person who's getting sued, but the other people that are insured too. That's a direct reference to the defendant. Then we have comments. Most of the time in this kind of situation, the insurance is going to pick it up anyway. They're the owner of the car and they have insurance and they're the ones with the money. Get an umbrella policy to protect yourself. I mean, your insurance company has to pay for the damage you do. Counsel says this was not preserved, that other than a couple of the comments by the insurance adjuster. I beg to differ, Your Honor. I think if you look at the transcript, you'll find that there were objections to all of these. Some were contemporaneous concerning the insurance adjuster. Some were a couple minutes later. The last one wasn't objected to until the end of the voir dire and before the jury was being sworn, in a motion that emphasized the cumulative effect of each one of these comments required a striking of the veneer. And I'd just like to quote again, I didn't quote before, the Pensacola case about this issue about inadvertence or who's bringing it up and so forth. The court said the injection by either party to a cause, whether deliberate or inadvertent, of any such improper influence in a jury trial, it's referring to reference to insurance, is a distinct disservice to the administration of justice, and courts, on their own motion if need be, must be ever vigilant to see that no such influence creeps into the proceedings, even in the slightest degree, and subverts the noble purpose of our court system to provide justice under the law. The court equated the single comment in that case, the reference to insurance, as a festering sore that resulted in a miscarriage of justice. We submit the same thing occurred here with a $30 million verdict that was returned. With regard to the set-off issues, Your Honor, the quote that counsel read from Addison is quoting from yet another case. And again, sometimes the court's using the language about joint tortfeasors, about the same claim being made against both defendants, because those are the circumstances of those cases. The key is, if you look closely at those cases, what you're really looking at is whether the damages being sued for are the same. That's the language in the statute, 768.041, that Judge LaBritte previously read into the record here. That's what we specifically argued in the trial court. Whether we cited to that statute or not, it was very clear that that's what we were arguing here. We've cited numerous cases that say that adequately preserves that issue. And so we think it's preserved, and it's just undisputed on the record that at least the 3.99 million above the UM benefits should be set off here. Dr. Shanasarian's testimony.
You need to kind of wrap up, counsel. We've just gone past by a little bit your time.
Thank you, Your Honor. Then we would rely on the briefs for anything further and just ask that the court reverse for those reasons.
Thank you, counsel. Thank you both. Well presented. We appreciate your assistance in this case, and we'll let you, I guess the word is to segue back to the other electronic area.
Thank you, Your Honor.
Thank you.
Thank you.